Hello, my name is Philippe Sands. I'm Professor of the Public Understanding of Law at University College London. I'm also a barrister who does cases about international crimes, and I've written a few books on the subject. I'm going to talk today shortly about the word genocide. Many people imagine that this is a term which conjures up great horrors and that it has existed for millennia. It has not. It was invented in the year 1944 by a Polish jurist called Raphael Lemkin, who had studied law in the city of Lviv, today in the Ukraine, and who in the 1930s became increasingly concerned about the way in which sovereign power was being used and abused in relation to people, citizens and foreigners. In the summer of 1944, he coined the word genocide, taken from two words, genus and side, Latin and Greek, to kill a group. And he worked hard to promote its broader usage. I first came across the origins of the word in preparing a lecture that I gave at the University of Lviv in 2010. And shortly after, in my search for archival material, I went to Columbia University and found a remarkable legal page document, yellow. It belonged to Raphael Lemkin, in which the word genocide, I think, appears for the very first time. It's undated, probably 1942 or 1943. He took the word forward, hoping that a new legal term would come into being to signal limits on the exercise of sovereign power. His hope was to protect groups from abuse, in contradistinction to the parallel development of the concept of human rights and crimes against humanity, which sought to protect individuals rather than groups. He had some success. He published his book, Axis Rule, in November 1944, as the Second World War was coming to an end, chapter 9 of which was entitled Genocide. It generated a great deal of interest. There were articles about it, a front-page book review in the New York Times Review of Books. This is that book. It's a first edition that I found in a bookshop. In fact, it's rather touching because it includes Raphael Lemkin's signature and a dedication signed in Nuremberg on the 4th of July 1946. If you turn to chapter 9 of the book, you will see that it is entitled Genocide. And this is the first published presence of that word. And the following summer in 1945, in London, at Westminster Hall, he sought to get the term introduced into the statute of what would become the International Military Tribunal at Nuremberg. He didn't quite succeed. It's not listed amongst the crimes in Article 6, paragraph C, but he did get it involved as a war crime in the indictment a few weeks later, in October 1945. And so, when the proceedings at Nuremberg opened in November 1945, on the first day, the word genocide was spoken in court. Curiously, the genocide word is not mentioned in the Nuremberg judgment, but a month after the judgment, the United Nations General Assembly at its first meeting endorsed the term as a crime under international law, and 2 years later, in December 1948, the term genocide was the subject of the first multilateral human rights treaty, the Convention on the Prevention and Punishment of Genocide. That convention has, in its definition, Article 2, what the term means. In the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. And then it sets out the acts from killing and torture and various other abuses. But the essential thing about genocide, what distinguishes it from war crimes and crimes against humanity, was the question of intent. You had to prove the intent to destroy a group in whole or in part. And that has proven to be a very difficult thing to do. Over the next 50 years, there was literally no practice at all in relation to the crime of genocide before national or international courts. That changed in the 1990s with the collapse of the former Yugoslavia and the crimes perpetrated in Rwanda, and genocide came back with a vengeance. In July 1998, the term was included in the statute of the International Criminal Court, and ever since it's been part of the life of international law. But its role in international law is complex, and it gives rise to many controversies and challenges. There is in particular a gap between public discourse about genocide, which essentially addresses any act which is particularly horrible, especially if it involves the killing of a large number of people, and the legal definition, which sets a very high bar, in particular the need to prove an intent, what motivates the act of killing. There are then today three main challenges for me on the crime of genocide. The first is proving intent. This is notoriously difficult. Of course, you can prove the intent to destroy a group in whole or in part if the perpetrator leaves bits of paper around saying they intend to destroy X or Y group. That's what the Nazis did in relation to Jews and Roma, people with disabilities, and so on and so forth. But that caused others subsequently to learn a lesson. Don't leave pieces of paper lying around. And so courts have been left to infer intent from a pattern of behavior. And this is where matters get very difficult. In fact, what has happened is the International Court of Justice, in a judgment of 2015, described the way in which you infer intent as follows. In order to infer the existence of the dolus specialis from a pattern of conduct, it is necessary and sufficient that this is the only inference that could reasonably be drawn from the acts in question. That is a very high threshold. It means that if someone has a double intent to defend themselves and to destroy a group, it could be said that the necessary inference could not be drawn. And in fact, psychologists will tell you that the individual human actor will often have a multitude of motivations or rationales for what they do, in which the intent to destroy a group may exist, but it may not exist alone. And so I've reached the conclusion that this very high threshold is deeply problematic and means that in many cases of the kind that Raphael Lemkin assumed would be met by the Genocide Convention, they will be excluded. It's very hard to prove intent. Almost impossible. Not impossible, but almost impossible. The second challenge is that the concept of genocide has reinforced matters of group identity, which did not exist in international law in the same way prior to the invention of the term. So what this means, in effect, is that if you want to prove a crime against humanity, what you have to do is that an individual has engaged in mass killing. You don't need to look at the intent. But to prove genocide, you have to show that the intent exists to destroy a group in whole or in part. And that has, in my experience doing cases over the last 25 years in the field of genocide and crimes against humanity, reinforced intergroup hatreds. It has meant that the victim group, in seeking to prove that the perpetrator group has perpetrated a genocide, develops very strong negative feelings towards that perpetrator group and vice versa. And the point that I've come to, as I've explained a little in my book East-West Street, where I explore all of these issues in greater detail, is that the invention of the concept of genocide, no doubt very well-intentioned, may have given rise to the very thing it was intended to prevent. The invention of the concept of genocide could actually give rise to more genocides. The third challenge with the term genocide is that the 1948 Convention provides for access to the International Court of Justice to address allegations of genocide. But there's no equivalent route to the International Court of Justice for crimes against humanity and war crimes. And so the consequence has been that allegations of mass atrocity tend to be shoehorned into the crime of genocide as a way of getting a day in court. This is obviously problematic because it skews public perceptions. It sends out a signal that somehow genocide is worse than other international crimes. It's not, in my view. Crimes against humanity are just as awful as are war crimes, and we need to think of a way to address this problem. What is to be done? I've thought long and hard about this. I've tried in various cases at the International Court of Justice to persuade the court to lower the threshold so that genocide is not so difficult to prove. But that has been resisted by successive decisions of the International Court, although I think there's still room there for the court to review the situation. We also plainly need parallel conventions on war crimes and crimes against humanity to avoid the kind of skewing that has taken place. And we need to think about the place of the group in our construction of legal and other norms. It's a difficult challenge. The term genocide is not going to disappear. It's here to stay. We probably need to reinvent it. We certainly need to think about how to avoid a skewing between it and other international crimes.